Welcome to Crime in Court. This is the 1996 Menendez brothers trial. We're reading through the transcript of the people of California versus Erik and Lyle Menendez on trial for the homicides of their parents, Kitty and Jose, which took place on August 20th, 1989. They have been behind bars for 35 years, and we are analyzing the differences between trial one and trial two. At this point, we are on, I'm going to shrink myself here so you guys can see my spreadsheet. We are on, and I apologize, it's kind of big or, expanding past the past the screen. But anyways, so we are on week 4, the very end of week 4. We're finishing up Friday, November 3rd. And this is, we're going to have some legal arguments, a lot of legal argument, and a brief recall of Detective Zoeller. There's going to be, I believe, some without the jury and then with the jury. So it's going to be briefly, we're going to read through his testimony. He's recalled, like I said, many, many times throughout this trial. And then on for week 5, we're going to read through the pathologist from the coroner's office. That's Robert Lawrence. We're going to read through his testimony and also a Dr. Roger McCarthy. I believe a lot of the legal arguments today are for those two individuals or, for future testimony. So just giving you a heads up on that. So let's get started. Please hit the like button. And we left off the last episode on Wednesday. We left off with Uncle Brian Anderson, and he had some interesting testimony. He, as you know, is not very friendly to the brothers, his nephews. He and his brother, these are both Kitty's brothers, sued the estate, meaning they basically sued the brothers for all the money. They and Carlos Baralt as well, because he was the executor. He also, or him and his brother Milton, testified on behalf of the state, trying to get the brothers the death penalty. So that's kind of where we're at with Uncle Brian. So he's off the stand now. We took a very brief uh, what's the word? Recess. That's the word I was looking for. So the both sides took a recess. I'm lost for words right now, and I can't think of what I'm saying. They'll resume in about 10 minutes with the hearings that we discussed before. Ms. Nahara says, okay, I think that's where we left off. So, and Ms. Abramson says, yes, we have a recess that was taken, and then the following proceedings were held in open court out of the presence of the jury. So, no jury in the courtroom right now. A lot of legal arguments are going to take place. Up first is Detective Zoeller's voir dire outside the presence of the hearing, or outside the presence of the jury. I can't speak today. Hold on. All right. The court says, we have a hearing to conduct here. Let's deal with Detective Zoeller's testimony. Ms. Nahara says, thank you, Your Honor. The people are recalling Detective Zoeller. Leslie Zoeller is recalled as a witness by the people, having been previously sworn, testified further as follows. The court says, all right, you can take the stand. You're still under oath. Just state your name for the record, and he does. Ms. Nahara says, Your Honor, for the record, I have a 3-page report that I'm marking Exhibit 166 for identification. The court says, okay. Ms. Nahara says, for the record, it is the Heffernan report. Direct examination begins. Ms. Nahara says, Detective Zoeller, on February 28th, 1991, did you talk to an individual named Mark Heffernan? Yes. Did you take a statement with him at that time? Yes, I did. A statement from him at that time? Yes, I did. Why'd you ask that again? And after you took this statement, did you take notes on this statement? Yes, I did. And at some point after you took this statement from him, did you memorialize it in a report? Yes, I did. Did you memorialize it in a report on March 28th, 1991? Yes. Have you had an opportunity to review that report? Yes, I have. And showing you Exhibit 166, would you take a look at this and tell me if you recognize what that exhibit is? This is the report of the interview of Mark Heffernan on February 28th of 1991. And does this report reflect both your notes and your memory of that conversation? Yes. And is it true and accurate and is it a true and accurate report of everything as you recalled it? Yes. Everything being the conversation. That's correct. And calling your attention to page 2 of that report, and specifically the fourth paragraph down, starting with the sentence, starting on the seventh line where it starts Lyle and going to the end of the paragraph, would you review that whole paragraph and when you're done, let me know? Okay. Does that paragraph accurately reflect your what was told to you by Mr. Heffernan? Yes, it does. For the record, Your Honor, may I read this paragraph into the record? The court says yes. Thank you, Your Honor. The paragraph being, quote, after the detectives had interviewed them, which was approximately 4 in the morning, both the boys came back to the house. Excuse me, came back to his house. He went directly to bed. His wife had to get up and go to work. He thought that the boys had gone to bed also. When he got up at 7, the boys had just returned. He asked them where they had been. They said that they took a taxi. They had to go back to the house, 722 North Elm Drive. He got dressed and he, Erik, and Lyle drove to the house. Lyle wanted to get back into the house before the police were done with the investigation, and he wanted Mark's wife, who works in an attorney's office, to contact a lawyer to get him into the house. Mark didn't think too much of this at the time because he was dealing with Erik's sadness. End quote. The paragraph that I have just read is that the paragraph that you have previously said accurately reflects the conversation you had with Mr. Heffernan? Yes. Is that what Mr. Heffernan told you? Yes, it is. Ms. Nahara says, I have nothing further, Your Honor. All right, we're into cross-examination now. Mr. Gessler says, yes, Your Honor. Detective Zoeller, do you have your notes of that February 28th interview? Yes, I do. May I see them, please? This is actually the right page. Is there any place in your notes that says Lyle wanted to get back into the house before the police left? No, not that exact quote. So the quote is, quote, Lyle wanted to get back in the house, wanted to contact a lawyer to get into the house. Isn't it? Correct. I have no further questions, Your Honor. I would object to Detective Zoeller reading anything beyond the part that they're offering for past recollection recorded, which begins with Lyle wanted to get back into the house. It's those two sentences. The rest of it is not subject to dispute from Mark Heffernan. He either had his recollection refreshed or wasn't asked. Ms. Abramson said, I would also object to anything before those two sentences being read because there was no failure of recollection as to any other part. The court says, well, I don't believe it's being offered. I think it was just read at this point to put it in context for me, but wouldn't be something that would be presented to the jury. Ms. Nahara says, that's correct, Your Honor. Court says, why don't you identify what exactly you propose to read? Ms. Nahara says, yes, Your Honor, and the court was correct. What I would propose eliciting from this witness is as counsel had stated. Quote, Lyle wanted to get back into the house before the police were done with the investigation, and he wanted Mark's wife, who works in an attorney's office, to contact a lawyer to get him into the house. Court says, okay, and that's what you propose to have Detective Zoeller read? Ms. Nahara says, that's correct, Your Honor. The court says, as a past recollection recorded statement of the witness? That's correct, Your Honor. All right, then that's what will be read. Mr. Gessler says, can I have just a minute? The court says, yes. Ms. Abramson says, it's subject to being a greedy pig. What? Get what you can, Judge. We only have crumbs. Actually, that's not the only reason why. I think the issue was brought out sufficiently through the testimony about my client's demeanor, but I think it gives, and the court says, I think your record isn't clear because I overheard you, so perhaps you ought to put it in the record as to what you're referring to. Miss Abramson says, I don't have the report in front of me. The sentence that I think should be included is Mark didn't think too much of this at the time, which is the next sentence because he was dealing with Erik's sadness. And I think that should be in there because it may explain why Mr. Heffernan doesn't have a recollection of telling this to Detective Zoeller and needs to have this brought in through past recollection recorded. Court says, well, that would be speculation. We don't have any reason to believe that. Okay, the request to add to it is denied. Of course it is. Before we get to the jury, however, as I understand it from what you told me, other than a representative of the coroner's office, there are no other witnesses here for the jury to hear, correct? Mr. Khan says, correct. The court says the prosecution has proposed that this particular representative not testify in front of the jury. What is the defense's position just on the foundational issues? Mr. Gessler says the defense's position is that we object. Ms. Abramson says, I think it's twofold. First of all, I don't have any objection to the witness testifying in front of the jury to the extent that she can. Our problem is, the court says no, they're saying there's no reason for her to testify in front of the jury. It's discretionary under Section 402 as to whether this type of evidence is presented before the jury. Ms. Abramson says, well, court says, anyways, the reason I'm asking that is as to whether we should excuse the jury after we hear from Detective Zoeller if there's nothing else from them to hear today. Ms. Abramson says, I understand that's why you're asking. I think depending on the court's ruling, I think we don't believe this witness will be adequate to make the record for reference to anything in the coroner's report. But if we are wrong and the court rules that she is, then she has to testify in front of the jury at some point because that's the only way they're going to establish a chain of custody for the coroner's evidence. We believe that she can testify in front of the jury to establish a chain of custody, but that she cannot do the task that Beeler requires. To wit, she doesn't have any idea what the medical procedures are of the office or whether autopsies are conducted in conformity with accepted medical procedures. And that's the foundation that we believe all the cases that we cited indicate they have to establish if any of the results of the coroner's examination are to be admissible. So that's the two levels of analysis of that witness. Sooner or later, I think, unless they bite the bullet and call the coroner, they're going to have to put her on in front of the jury. The court says, let me inquire of the prosecution. Did you intend to offer physical exhibits that were obtained from the bodies of the decedents during your case in chief, or just photographs and the content of a report prepared by Dr. Golden? Mr. Khan says, we'll simply be offering into evidence photographs and x-rays that the experts will rely upon in forming their opinions. It's not necessary for us to introduce the actual physical exhibits, although the Detective Zoeller was there for the recovery of the physical exhibits, that is, the pellets and the wadding from the bodies. And I believe that he can establish sufficient foundation for that if he has not already done so. Court says, well, I'm just asking whether you intend to pursue that or not. I'm not suggesting you should do one thing or the other. I just want to find out the limits of the hearing. Mr. Khan says, yes, we'll offer then the pellets and wadding through the testimony of Detective Zoeller. We'll also seek to have the experts rely upon photographs and x-rays that were taken at the time of the autopsy, and by establishing the foundation for those photographs and x-rays through the custodian of records, we'll ask that they be received into evidence. As far as the actual autopsy report of Dr. Golden or the addendum to the report, we'll not be offering those reports themselves. We'll simply have our experts review those and take those into consideration in forming their own conclusions concerning the wounds in the case. Ms. Abramson says, Your Honor, that of course puts me at a peculiar disadvantage because I need to impeach these witnesses on cross-examination with the findings of the autopsy surgeon, which is Dr. Golden. Court says, well, he said that, as I understand it, Mr. Khan, the experts you call or witnesses you call will have relied upon the entirety of Dr. Golden's report, including any addendums to the report. Is that correct? Mr. Khan says that's correct. In forming their own independent conclusions, they will consider and rely upon that material. The court says, including the last addendum to which you had some objections to its conclusions. Mr. Khan says correct. Court says, all right. So then the defense would be in a position to use that report to impeach. Ms. Abramson says, yes, I could technically, except it won't have a foundation, that report, because this witness, the custodian of records, can't authenticate the veracity or accuracy of that report, and Detective Zoeller certainly can't. The court says, well, as far as there are two issues here in regard to the report. Number one is the physical observations of Dr. Golden, some of which apparently are in dispute, as well as any conclusions, medical conclusions that he formed, which normally are not admissible, the medical conclusions other than generally the cause of death being gunshot wounds. But the specifics of it often are medical conclusions that are not admissible as Ms. Abramson interjects and says they're admissible if he testifies. The court says, yes, I'm talking about the report itself, the body of the report. Normally, you have another pathologist come in and testify to his independent opinion as to the cause of death and nature of wounds and things of that nature. And the report is only received for the description of the wounds and the observations, physical observations of the coroner. If the people are calling their witness and having the report relied upon by the witness in forming opinions by that they are establishing the report exists and how it's prepared. Ms. Abramson says they can't establish how it's prepared, Judge. For some reason, there's a pause in proceedings. Then the court says, what I'm getting at is we have a situation where there is no dispute really by either side as to the authenticity of the report or its mode of preparation or its reliability in general. Nobody's disputing that in this case. You're going to call Golden in your case in chief. The people want to establish that the report can be relied upon. They're not disputing it's prepared in the ordinary course of business and done so with the type of procedure one would expect for a report to be prepared in the ordinary course of business. Both sides are agreeable to that. There's no dispute. So we really would have a hearing or have testimony about something where there was really no dispute and the people's position from what you feel or filed, sorry, from what you filed, the people filed here is that it's already been established as far as the court is concerned by reason of Dr. Golden's testimony in the first trial that it's been proved that the report, that's how Ms. Amerson says, interesting way to do it. If the people want to stipulate in front of the jury that Dr. Golden used appropriate methods and his report is reliable and accurate, fine. Mr. Gessler says, we'll do that. Ms. Amerson says, we'll do that. The court says, it depends on what you mean by reliable and accurate. I suppose there's a dispute. That's why they don't want to call Dr. Golden. Ms. Abramson says, right, and they want to rely on the report and trash the report at the same time. They should have to choose one or the other. They can't have both. Court says, well, Mr. Gessler says, Your Honor, I think the problem is that at least in part, whether it's Dr. Lawrence or anybody else, it has to be based on a description of the wounds which comes from the report, whether or not the opinions of the pathologist are given as to entry wounds, exit wounds, distance, or things like that. Description of the wounds is very important to anybody examining or cross-examining in this case. Court says, right. Mr. Gessler continues, and we have not had any witnesses come in and talk about the medical procedures being used for the measurements of the wounds, the probing of the wounds, the different things that were done. So, to that extent, I think Beeler controls, and we need to have somebody come in and talk about medical procedures. Court says, all right. Ms. Amerson says the judge is saying no one is disputing the medical procedures. Mr. Gessler says, well, if no one is, as you say, if they're willing to stipulate, Ms. Amerson says proper procedures were followed. Court says perhaps you can work out a stipulation as to what it is that you're stipulating to, so that both sides can then present to the jury the issues that you think are pertinent rather than dealing with things that really aren't in dispute. There are some things that aren't going to be in dispute as far as the general protocol followed by by Dr. Golden. I assume there's not going to be any dispute about that. Mr. Gessler says perhaps we should take 5 minutes and have Bosnia peace a Bosnia peace conference with the court says you have to go to Dayton. I don't know what they were referencing. Mr. Kessler says we don't have to go to Ohio. We can do it here. It must be some pop culture thing that's happening at the time. I have no idea. Um, we can do it here and talk to Mr. Khan and Ms. Nahira. Maybe we can work out where we agree or disagree. Did my camera stop? It really did. Hold on. Sorry about that. I don't know. My camera is being, or my computer is being slow. I think it's my internet is being slow today. So apologies. I might just have to shut the camera off if it keeps doing that. Anyways, the court says you have to go to Dayton, whatever that means. Gessler says we don't have to go to Ohio. We can do it here and talk to Mr. Khan and Ms. Nahira, and maybe we can work out where we agree or disagree. The court says, well, it's certainly possible because, as I said, it's a unique situation in that both sides have no dispute with the general concept of the autopsy being performed in the ordinary course of business and in medically acceptable fashion. There's just a dispute about the ultimate findings. And rather than consume a lot of time and debate about things that aren't in dispute, perhaps we should just focus on those things that either side wants to prove or disprove. And this is a situation where the medical examiner is available and his availability will be established by the fact that you're calling him. Ms. Abramson says, sure. Court says, and I assume you'll be calling him rather early in your case. Ms. Abramson says, like first. The court says, so it will be just following the prosecution's presentation of evidence, so it's not going to be a mystery. Ms. Abramson says, and we would, since he is going to be called, object to Detective Zoeller giving anything even coming close to opinions of recovery of evidence. He doesn't know where inside the body those things came from. The court says, it seems to me if Dr. Golden is going to be the next witness, it does seem to be rather wasteful of time for Detective Zoeller, don't want to call him a doctor, for Detective Zoeller to describe finding certain things where things were found if Dr. Golden was there and found them and can actually identify where things were found. So, to that extent, I would agree with that observation. And again, the purpose would be to cut down on the litigation that doesn't prove anything. It might create some heat and fireworks, but it might not prove anything other than just getting us to the stage where you're going to get anyway with your witness and with the defense witness. Ms. Amerson says, so as long as they don't challenge that Dr. Golden followed the proper procedures, that he saw what he saw, that he measured what he measured, that things were where he says they were, we won't have any dispute. But if they're going to get into that he's an idiot and he can't see things or he overlooks something, then we have a problem. The court says, well, there obviously could be that debate, and that debate could exist whether or not you had someone else from the coroner's office testify about how things are done to the ordinary course of business. Ms. Abramson says, well, I don't think that's likely to happen again. Court says, oftentimes the medical examiner who did the autopsy is unavailable and someone else comes in, and that person who comes in and testifies cannot say that everything that was done by the person who actually did the autopsy was done in a certain precise way. All he can say is it appears to have been done in the ordinary course of business as prepared. Ms. Abrams says they testify to the ultimate conclusions as well, and they don't usually trash their colleagues. That's only happened once that I'm aware of. Court says that's a separate issue, and that will be dealt with during the examination of the substantive witnesses rather than the foundational aspect of it. Anyway, excuse me. Anyway, I agree with Mr. Gessler. If you can just see if you can resolve this, it would help me in deciding whether to keep the jury to hear the witness for some other witness this afternoon. I don't want to get into a lengthy recess here because oftentimes after a long recess you can come out and nothing's been resolved and we're at square one. Ms. Abramson says, how about a brief recess? Mr. Gessler says, if we can't do it in 5 minutes, we can't do it. The court says, let's make it 20 minutes after the hour and let me know how you've resolved the issue if you have, and then we'll at least have the jury come out and deal with Detective Zoeller's testimony. Ms. Nahara says, Your Honor, just real briefly, housekeeping matter. Before he testifies, there will be another stipulation, and then there will be one issue just kind of got overlooked when I examined him earlier, and that was the third thing I'll ask is if he went out to that address that was given to him at Big 563 August Street, and whether or not that location existed, which it didn't, and everybody knows that. The court says, "Okay, I'll permit you to reopen to ask those questions." Ms. Nahara says, "Thank you." 20 after the hour. Then a recess is taken. Then the jury enters the courtroom, and the following proceedings were held. All right, the court says the jury is back, and the reason we took so long is that we're trying to finish up some loose ends in the case before we get to the next phase of the evidence, which will be presented on Monday, dealing with medical examiner type evidence, autopsies, that sort of thing. But we had some loose ends that we had to deal with, and that's what took some time this morning. The parties have a little bit more evidence to offer this morning, a stipulation, and then there won't be any more evidence today for you. We'll be taking a break until Monday, but we had some things that we had resolved this morning. So the people, I think, wanted to call Detective Zoeller back. Is that right? Ms. Nahara says, yes, and Your Honor, I have two other little stipulations which can be before or after him, whatever. Leslie H. Zoeller was recalled as a witness by the people, having been previously sworn, testifies further as follows. The court says, okay, say your name again, and he does. He's still under oath. Thank you, Your Honor. Ms. Nahara says, thank you. Direct examination begins. Ms. Nahara says, Detective Zoeller, on September 11th, 1989, did you have a conversation with a salesperson named Mary Ellen Maher? Yes, I did. And was this at the Slavik's jewelry store on Santa Monica Boulevard? In Century City, that's correct. May I approach the witness? Yes. Showing you Exhibit 120, would you take a look at that? Okay. Now, do you recall having a conversation with Ms. Maher on that day concerning a conversation she had or she heard between the defendant, Lyle Menendez, and another individual on the telephone? Yes. And do you recall what it was that she told you at the time concerning just that conversation? Yes. And what was said? It's a quote, and it's quoted in the report, if I may read the report for the quote, if you would. Quote, I need $100,000 advance from the company immediately, no matter what it takes. And who did she tell you said that? Who did she tell you said that? That's an odd way of saying who said it according to her. Lyle said that the person on the other end that was Lyle said that to the person on the other end. And did this conversation take place while he was in the Slavik's jewelry store making a purchase of some watches? Yes. And there would be an admonition on that statement, Your Honor, according Ms. Abramson asked. Court says, yes, that's being received only as to Lyle Menendez. Thank you, Your Honor, says Leslie Abramson. And Ms. Who's doing the questioning? Mr. Khan or Ms. Nahara? I thought it was, yeah, Ms. Nahara. She didn't fix this to say it's not, oh, by Ms. Nahara. She did, and I just can't read. Sorry. Ms. Nahara continues on with her questioning. She says, Sir, on February 28th, 1991, did you have a conversation with an individual named Mark Heffernan? Yes, I did. And specifically, did you talk to Mr. Heffernan about a conversation he had with the defendant Lyle Menendez the morning after his parents, Mr. and Mrs. Menendez, lives were taken? Yes. And showing you what's been marked as a previous exhibit, would you look at that and tell me if that reflects the conversation that you had with Mr. Heffernan? Yes, it does. And with regard to merely the statement, the one statement that Mr. Heffernan made to you regarding what the defendant, Lyle Menendez, told him that morning upon returning from the house, can you tell us what it was that he told you? Again, may I read it? If you can, if that will help you to remember it, sure. I remember it. Okay. The statement was, is Lyle told Mark Heffernan that he had to get in the house before the police were done with their investigation, and that to enable him to do this, he was going to have Mark Heffernan's wife, who works for an attorney, try to get him an order to get in. And, sir, calling your attention to a big blow up, Exhibit 58, this is a blow up of some ATF, some firearms transaction records that I believe you testified to previously. And on this blow up is an address of an individual who supposedly bought shotguns on August 18th, 1989. The address that was on the firearms transaction, 63 August Street. Did you ever, in San Diego, California, did you ever do anything in regards to that address? Yes. And what did you do? I looked in the Thomas Guide, the San Diego County Thomas Guide for an August Street. The only August Street I found was a 5,000 block on August Street. And I drove to that location, the August Street that was listed in the Thomas Guide, and verified it was only the 5,000 block. There was no address of 63 August Street. Ms. Nahara says, thank you, sir. I have nothing else. And the court says cross-examination. Mr. Gessler has no questions. Ms. Abramson has no questions. The court says, all right, thank you, sir. You may step down. So now we're going to get into a couple stipulations and some more legal argument. All right, so the court says, do you have some stipulations? Ms. Nahara says, yes, I do, Your Honor. Court says, all right, now the now the lawyers have some stipulations, again, agreements about certain things that are not in dispute. Ms. Nahara says, counsel, will you stipulate that Exhibit 102 is the patio home reflected in the documents that are Exhibit 147? Mr. Gessler says, also stipulate. Ms. Nahara says, and counsel, will you also stipulate that Exhibit 103 is the condominium reflected in the documents that are Exhibit 148? Mr. Gessler says, I'll stipulate it as a picture of the condominium. Ms. Nahara says, thank you, and I appreciate that, counsel. And the people join in the stipulation, and we thank you. The court says, okay, those stipulations are noted. Again, that evidence was offered and received only as to Lyle Menendez. Ms. Nahara says, thank you, Your Honor. The court says, all right, there's another stipulation. Mr. Khan says, yes, Your Honor. We would also stipulate at this time that standard medical procedures of the Los Angeles County Coroner's Office were used in the autopsies of Mary Louise Menendez and Jose Enrique Menendez as to observations of wounds, measurements of wounds, determinations of entrances and exits of wounds, determinations of directions of wounds, and determinations of whether wounds were made before death, at the time of death, or after death, and as to determining what the causes of death be. It is further stipulated that standard procedures of the Los Angeles County Coroner's Office were used in documenting the results in autopsy reports, supplemental autopsy reports, and accompanying diagrams. Mr. Gessler says, I so stipulate on behalf of Joseph Lyle Menendez, Joseph Lyle Menendez. Ms. Abramson says, so stipulated on behalf of Erik Menendez. The court says, all right, then that stipulation is offered and received. And at this point, then, there is no further evidence to be offered today. The next witnesses will be coming in Monday, and I'll be excusing you at this point with the admonition not to discuss the case with anyone, not to form any final opinions about the case, not to permit yourselves to be exposed to anything about the case in any form whatsoever, whether it's in news coverage, overhearing other people talk about it, or anything of that nature. Just make your decision only on the evidence you see in the courtroom. All right, we'll excuse you, and you all have a good weekend. We'll see you back here Monday at 8:30. Jury exits the courtroom, and the following proceedings are held. Court says, okay, still to be discussed is potential objections by the defense to certain photographs that the prosecution might use during the examination of the next two witnesses, and I'm unclear as to whether or not the prosecution has shown those photographs to the defense or if they have all of them, or whether there's some decision made that you're not going to be using some that they do have, or whether or not it's at this point germane to this stage, whether we can discuss it. Ms. Abramson says, I share your not being clear, Your Honor. I asked Mr. Khan to please show me the photographs he intends to use. What he's told me twice is that the only photographs he intends to use are the ones that appear on Roger McCarthy's most recent CD-ROM. Now I find that hard to believe because we've just stipulated to the coroner's record of evidence, which includes a larger number of photographs than what appears on Dr. McCarthy's CD-ROM. But let's assume they're telling the truth, or that rather than implying that he's willfully not telling the truth, let's assume he's being accurate. I have here a printout of the photographs that appear on the CD-ROM, and I can highlight for the court the ones that I have objection to and demonstrate to the court why I'm objecting. But I think it might be useful if the court has this to look over for a few minutes so you can see. As a general proposition, we think there are a redundant number of especially gruesome photographs of Mrs. Menendez that serve no adequate scientific purpose since they're all showing the same wounds and they're just piling grim on grim. The court says, okay, let's do this then. If you've identified those that you object to, let me first verify. These are all the photographs that you'll be using in your examination of the witness. Mr. Khan says, I've never seen what counsel's referring to. Ms. Abramson says, I showed you this the other day. Mr. Khan says, counsel has never showed me what she has. Ms. Abramson says, this is the printout. Mr. Khan says, I've never seen this. Okay. Come on, buddy. Be honest. The court says, why don't you look at it without further debate? Look at it now. Stop being a jackass. Ms. Amerson says, I showed this to you, and I showed you which ones were new. Mr. Khan says, I've never seen this before. Ms. Abramson says, well, you have the printouts of Mr. McCarthy's CD. The court says, let's not just debate whether he did or didn't see something. Let's just do it now. Pause in the proceedings. Then the court says, are those photographs that you're going to use? Mr. Khan says, yes, I think that there may be one additional photograph as I was going through them this morning. There are apparently a wound. The bailiff says jurors are walking. Let's let the jurors have leave first, the court says, and then the jurors leave the jury room. So I think they're in the jury room, which is inside the court. They had to go back, get their things, and then they have to leave. So that's why I think they're in and out. The court says, okay. Mr. Khan says, yes. As I looked through the photographs this morning, I noted that there was only one wound, which I think is not depicted in any of the photographs, and that there is an individual pellet there is an individual pellet defects to the inside of the right arm of Jose Menendez, which appeared prior to the time of the autopsy. I think that area was then cut away and those defects were no longer visible as a result of that incision. So we'll probably introduce just that one more photograph which will depict those individual pellet defects which McCarthy has not included in his CD-ROM that has been provided. I'm sure that there will be discussion concerning that one wound which is not depicted in any of the photographs. So, with the exception of adding that one wound, I think that the other photographs which counsel has identified are sufficient to depict all of the wounds at this time, as far as I can tell. The court says, okay. So the defense has objections to certain of the wounds photographs, and you've marked them in the exhibit. Ms. Abramson says, I'm in the process of doing that. I'm asking counsel right now, Your Honor, to identify which photograph it is that he wants to use. Court says, okay, well, that's just an additional photograph. Right now, I'd like to focus. Ms. Abramson says, I want to make sure I don't object to it. All right, what I'm doing, Your Honor, is I'm marking and I'm saying object. There is numerous photographs of Mrs. Menendez and objecting to the duplication. Court says, okay, why don't you just show me the ones that you object to, and then I'll review them and we'll discuss them after lunch. Ms. Amerson says, right, I'm just putting little post-it notes with the word object. And I also want to show the court, and I showed this to Mr. Khan a week ago, since all these photographs are on computer or on CD-ROM, they can be easily cropped. And I'm just going to give this to you as an example. This is one that they just added to Mr. McCarthy's CD-ROM, which is particularly grisly because it shows an open mouth, and we cropped it on the computer, cut off the part that was grisly, just as an example of how these photographs can very easily be cropped. And with respect to the most recent one that Mr. Khan indicates they want to use to show the individual pellet defects, we would ask that this should be cropped. There's no reason to show the face or the head in this one, so I'm writing object unless cropped. And we'll be very happy to prepare the cropped photograph for the prosecution if they have any problem with it, because I'm going to be doing that this afternoon. And here's the photographs. The court says, all right, I'll review them and then we'll discuss it in the afternoon at 1:30. Mr. Khan says, does counsel have a list of the ones? The court says, if you want to look at them now, you can look at them and then I'll look at them and then just leave it here and I'll pick them up. Okay, we'll be in recess until 1:30 if you can just leave them on the clerk's desk when you're through. Ms. Abramson says, Judge, can we have until 2? The court says, okay, 2. At 12 p.m., the noon recess was taken until 2 p.m. of the day. So they took a 2-hour lunch. How nice. Then they come back and at 2:10, so they're late. And the court says, okay, the defendants are in court with the lawyers, the people are present, the jury isn't here. We're going to discuss the proposed exhibits from the prosecution. The court has looked at the photographs, and I assume everyone has the same as I have. Is that right? Ms. Amerson says, no, you've got the only copy of that printout. Everybody has the photographs. You've got the only copy of that printout. And you know, Your Honor, I am looking right now at a set of printouts that show how Dr. McCarthy was using these photographs to illustrate the different shots. And it might be useful I know it's complicated, but it might be useful for the court to see it. Court says, by the way, this is an open session if there is any public out there. So public, the public is allowed to listen to this. Ms. Amerson says, yes, there are some people outside. The court says, you were saying? Ms. Amerson says, yes, Your Honor. I also have, based on Dr. McCarthy's testimony, what he did in court, we assembled on separate sheets all the images he called up to illustrate each of the shots as he numbers them 1 through 12. And I think that this highlights the nature of my objection that he is using far too many repetitive, gruesome shots to illustrate a single point. I wish I had more of these. These are very hard to make, but let me stand with Mr. Khan so he can see what I'm talking about, and then he can hold them up for you to see. For example, this is all of the images that you used before, and I am assuming there isn't going to be any deviation to illustrate what he calls shot number 1. Shot number 1 is the one that goes through Jose Menendez's left elbow, according to him, which is here. It goes through the right arm, which is in this picture, and a tiny bit in this picture, and then it supposedly goes into Mrs. Menendez's left breast, which is in this picture. All of these images, I have no objection, except perhaps to this one, which is called 1 Joseph, only because the head is totally irrelevant to what's trying to be illuminated there, which is this tiny piece of the arm, and I would ask that it be cropped. But that's how he presents the narrative, if you will, through photographs. And basically, I don't have a lot of problem with these particular sequence narrative, except perhaps for one Joseph, which is not the worst of the pictures. Now, on the most recent program CD that we got, there were the additional photo pictures that on the sheets I gave the court have the word new on them. I don't know how they integrate into that CD yet, but let me show you what he was using for two, which is according to him the shotgun wound to the back of Jose Menendez's head. When Mr. McCarthy did his first presentation, he did not have the coroner's autopsy photographs. What's before the court now and labeled new and does not have an objection on it is a different picture of the back of the head, one that we argue is more probative than this picture, which is also included in this package that the court has. The picture, which is called 3 Joseph, is probed. It's been torn up by the coroner's office and it's bloody and gory and doesn't show anything about the original shape of the wound or the direction. The court says, I'm trying to find the one you don't object to that's labeled new. Ms. Abramson says, it's the only other shot straight on the back of the head. Court says, yeah, I saw it here. I was just trying to find it. Ms. Abramson says, can I approach, Your Honor? The court says, I saw it once before, so I'm sure I can find it. Mr. Khan says, the one that counsel doesn't object to is labeled 6 Joseph. Okay, I see it. You see it? Yeah. Miss Abramson says, so our contention is obviously 6 Joseph is a more probative photograph and a less gruesome photograph than 3 Joseph, and that is the basis of our objection to 3 Joseph, and that is they have a much more probative way and less inflammatory way of illustrating the size and contact nature of that wound, if you will, because 6 Joseph shows all the radiating fractures and tears from that wound, which is part of the medical opinion. I assume even of Dr. Lawrence of why that's a contact wound. Okay, shot number 3, the one that he says passed through, and that's just the outdoor photographs, and there is no objection to any of that. But here is a real issue of overuse of gruesome by Dr. McCarthy. These are the frames being used for the description of shot 4. Shot 4, according to Dr. McCarthy, is the upper right side of the face of Mrs. Menendez, the part that I'm covering with my hand, indicating. Uh, she's indicating it. Sorry. The court says, okay, and Ms. Abramson says, but this is what he wants to use to illustrate it no less than 4 grotesque photographs of Mrs. Menendez that show not only shot 4, but also shot 5, which is the arm wounds, shot 1, which is the left cheek shot, it's the coroner shot, 2 and 3. I don't know let me see what McCarthy sees or calls it. McCarthy calls it's shot 6. But in any event, it shows all of the wounds to her head and face. And this one, for example, 12 Mary, hardly shows what he is talking about, which is the right side of the face. 14 Mary shows all of the wounds, and my suggestion is since it shows all of the wounds, that one photo could be used for all of those wounds to the upper part of the body because it shows each and every one. He also uses 8 Mary, which hardly shows the wounds in question, and then he uses 10 Mary, which is the most grotesque of all, but at least one could say is the one that most shows that particular shot. I don't see any reason in the world except for inflammatory purposes. There you go. That's how he aligned them, not that one. In fact, that one he saves for later. Mr. Khan says, I see. Ms. Abramson says to show that one wound to the upper right part of the face. Here is where he shows that one. That's 12 Mary. Now, he does the same thing and also with very little logic for his shot number 5, which is the same of coroner's 5, and that's just the double arm wounds. Her right arm has got a crease in the forearm part and a crease in the upper right arm or upper arm part, but he doesn't stop with the arms. He shows 12 Mary, which is particularly disturbing because it shows Mrs. Menendez's left eye open. He shows 5 Mary, which is only half of the wounds, the forearm part. He shows 7 Mary, which is the other half of the wound, the upper arm part. He shows 13 Mary, which is both parts, and 14 Mary, which is again the whole head and both parts. There is just no reason in the world why they need 5 pictures to show an arm wound and all those shots of her face to show an arm wound, which is unaffiliated in both Mr. McCarthy's version and Dr. Golden and all of the other pathologists and experts' versions with the face wounds. The arm wound is clearly separate. Mr. Khan says, "Can I see those?" "Certainly, certainly." Now here we go again, almost the same pictures repeated again for shot number 6, which, according to Dr. McCarthy, is the shot involving the right mandible, which is the chin and clavicle, and a right hand. There is no dispute, in fact, among any of the experts who are working on this case now or who have ever consulted on this case that the right hand, right clavicle, right mandible is an associated wound, and there is one photograph here and only one that shows that association, which is what's numbered 13 Mary. But he wants to do it in with 10 Mary, a particularly gruesome shot that only shows a portion of the wound, the mandible, and a portion of the clavicle. He wants to do it with 12 Mary, which is shot from the other side of her body, which hardly shows those wounds at all. He wants to do it with 8 Mary, which doesn't show the hand and doesn't show the clavicle well, and 13 Mary is the one that best shows the association. But not content with that, but not content with that, he also wants to use 6 Mary to show the hand and 9 Mary to show the clavicle. So we have here 6 photographs to show an injury to the hand, mandible, clavicle that one photograph shows. I mean, her arguments are solid. So, but we'll see how the judge rules because he doesn't seem to favor the defense very much in his rulings. Ms. Abramson continues. Now the next is shot number 7. Shot number 7 is the photograph of wound number 7. We have no problem with that one. The next one is what he calls shot number 8, which is to Mrs. Menendez's thigh hip. We have no problem with that one. The next one, that's interesting, is shot number 9, which is maybe not the most accurate photograph of the in and out above and below the knee wounds, but we have no objection to it. Shot number 10, I think he may have added to this because on this original showing of 10, he doesn't show the left leg graze wounds. But there is a picture of it, I believe, in the new category, and I don't object to it. Shot number 11 is to show the shoulder left below the ear of Mrs. Menendez, and he has picked the only 2 photographs that actually illustrate that. So I have no objection to that. I am not trying to object because they're ugly. They're all ugly, only if they're not probative enough. Then 12, we really go to town on 12. 12 is what the coroner calls number 1. It's the left cheek. It's a contact wound. It's birdshot. There is a dispute in this case as to whether that's the antemortem, perimortem, or postmortem. So certainly it makes sense to illustrate it. But what he's trying to illustrate it with are all 4 photographs, one of which 10 Mary barely shows the wound, 8 Mary shows it from a great distance and doesn't show the angle of it. 12 Mary, we have talked about before, is especially gruesome because the dead eye is looking right at you. I mean, I realize that is what it is, but and then 14 Mary seems to be the only one, and it's pretty gruesome, but it's the one that illustrates virtually every shot to her head, and it's the one I didn't object to because it seems to me that 14 Mary, which shows the arm and the hand and the clavicle and the mandible and the right side of her face and the left side of her face, shows everything, and there is really no need to use all those others, which you have one picture that shows it all. So that's the nature. That's the nature of our objections. The court says, okay. And Mr. Gessler, anything further, or are you just adopting? Mr. Gessler says, no, we join in the motion, Your Honor. Okay. And the people want to respond? Mr. Khan says, yes. Miss Abramson says, there is only one other thing I would add to this, Your Honor, and that is really there has been no scientific basis given, no basis for these photographs because these are Dr. McCarthy's choice. These are not the coroner's choice. These are not Dr. Lawrence's choices. These are what Dr. McCarthy wants to project on what appears to be a monitor rather than a screen in indeterminate size. So there is no showing that this illuminates a medical opinion, which he can't give. The court says, I am assuming that Dr. Lawrence will be using these photographs to illustrate medical opinions. Ms. Amerson says, well, but I should point out most of these photographs with respect to Mrs. Menendez and the head wounds, there is really no dispute about those. So I don't know why you would need 5 or 6 or 7 or 8 different shots of something that no one is really disputing. The court says, okay, let me hear the people's response. Mr. Khan says, yes, first of all, the entire premise of counsel's presentation is based on fallacy, and that fallacy is that whatever was asked of Dr. McCarthy in the hearing are the only questions that are going to be asked of him before this jury. It's based upon the premise that Dr. McCarthy is going to select which photographs should be shown to the jury, and the court specifically said that that's not the way it should be done. The attorney should present the photographs to the expert rather than the expert flipping through the photographs and presenting whichever photographs he wants to the jury. So, counsel's entire argument is without foundation. The issue before the court is what photographs should be presented to the jury in order to illustrate the wounds that were inflicted to the victims in this case. So rather than going through Dr. McCarthy's selection of what photographs are necessary to present his case, we are looking at what photographs are necessary both for the testimony of Dr. McCarthy and for the testimony of the pathologist in this case, Dr. Lawrence. So, the issue is what photographs are necessary to clearly demonstrate to this jury the nature of the wounds involved in this case. Now, counsel every now and then will refer to, well, this is not in dispute, that is not in dispute. I don't know what is in dispute. Counsel has never sat down with me and told me these are the following items my experts are going to contest. I have no idea what is in dispute in this case. What I am prepared to do is present photographs to the jury which will illustrate to them the nature of the wounds that were inflicted in this case, and as we go through the photographs, the only relevant determination to be made is whether some of these photographs are necessary. And if they are unnecessary, then I agree they should not be presented to the jury. So if we start with photographs of Jose Menendez, I think that's most easily resolved. There are 2 photographs that are in dispute concerning Jose Menendez. That is one Joseph, which depicts his full body, and 3 Joseph, which depicts the back of his head. They have apparently cut into his head, and I agree with counsel. I don't see any reason why 3 Joseph needs to be presented because, in light of the photograph, which has recently been added, 6 Joseph, I think that adequately depicts the wounds to the back of the head. So I have no problem at that at this time, unless some need arises during the testimony, which I don't anticipate at this time. I have no problem to withdrawing 3 Joseph. As far as one Joseph is concerned, one of the purposes I think for which that photograph is being offered is to depict the wounds to Joseph's right arm. Now, as counsel knows, the key wound that is going to be in dispute throughout all the days of testimony we are going to listen to from these experts is the wound or wounds to Jose's right arm. That's going to be the focal point of many of the questions put to the experts in this case. We have only 2 photographs of that wound, one of them for Joseph, to which counsel is not objecting. The question then is, are we going to proceed with days and days of testimony under numerous expert witnesses uh, concerning that wound with a second angle? I have no problem at this time with just for the sake of keeping it as simple as we can with not using one Joseph, but I have a hunch that before this hearing is over and before the trial is over, the jury is going to see a lot of these photographs that they're not going to be shown up front. The court says, well, doesn't this additional new photograph show that same wound? Mr. Khan says, yes, it does. It's the only other right. No, the new one. Huh? The court says, for Joseph, this new photograph and one Joseph show that wound. Is that right? Miss Abramson says, can I approach to look at the new one? Because I pulled it from my book. Mr. Khan says, no, the new one I understand, is Joseph 6. Miss Amerson says, no, there is another new one that I pulled out. You said there is one missing, and I pulled it out from my book to show the judge. Can I have that back for a minute? You wanted one that showed the antecubital fossa. Mr. Khan says, correct. And Ms. Abramson says, and I am objecting. I want the head taken out of this picture. That shows the wounds you are talking about. Court says, I just mentioned it. Ms. Abramson says this is a better picture. Mr. Khan says, I have no problem, particularly in light of the fact that photograph I think also displays the wounds pretty well. So I have no problem, at least at this point, withdrawing Jose 1 or Joseph 1 in addition to, and then Ms. Amerson says 3 Joseph. Mr. Khan says 3 Joseph. Ms. Amerson says, okay, and you're going to substitute this one, whatever we wind up calling it, but can I prevail on cropping the head? Mr. Khan says, my only problem with cropping the head is we do want to present this so that the jury can see the photograph as well. The court says, I don't see any reason really for that photograph to remove the portion that shows the head. It just shows a perspective of the body and makes it more identifiable where the wound is. So I don't see any need to crop it. Ms. Abramson says, all right. Court says, it shows the wound and it shows if there is any significance to the injuries to the right chest area. Ms. Abramson says, there is a great significance to that. Court says, okay, so it shows that in relationship to the wounds to the right arm. Ms. Amerson says there are also numerous photographs from the scene when the coroner's representatives are there that also show that right arm wound from behind that we are going to be using. So the court says, okay. Ms. Amerson says there are plenty of pictures of that right arm wound. Court says, okay, so people are agreeing to withdraw 1 and 3. Mr. Khan says yes. Court says okay. Mr. Khan says, so that takes care of Jose Menendez. We are only concerned with 5 additional photographs at this time. Ms. Amerson says correct. Mr. Khan says one of the other key areas in contention in regard to the expert testimony will be that wound to Kitty's left cheek. That is, whether that wound is a post-mortem or antemortem wound, and I don't see how counsel can say all of these depict the face and nothing is in dispute concerning the face. Obviously, there's very much in dispute. This is a wound to her right cheek. Mr. Abramson says left cheek, counsel. Mr. Khan says this is an area where Dr. Golden, after testifying before the grand jury, testifying in the trial, and maintaining his position for 5 years, that this was a perimortem wound, antemortem wound, has now decided on the eve of trial, upon second reflection, he thinks it's perimortem or postmortem. That very much that's very much going to be in dispute in this trial. We have one photograph of that wound, which I think that counsel is not objecting to, and that is, Ms. Abramson says, my position is if there's one photograph that can show them all, that's the photograph that should be used rather than 5 photographs to show them all. The court says 14. Ms. Abramson says, I think it's 14, Mary. Mr. Khan says, then the question becomes, is that photograph different from the other photographs? Well, when you look at 14 Mary, the interesting thing about that is you see a very dark edge all along the left side of the wound, which upon looking at other photographs of the same wound, I suspect is just a shadow rather than darkness of the wound itself. So I think it's important not to just give the jury one photograph concerning that wound when that wound is going to be so hotly contested. I think the photograph that depicts that wound sheds additional light literally and figuratively upon that wound is 12 Mary, because 12 Mary shows at least the right side of that wound much more clearly and with greater light. So I think that testimony and photograph is going to be before the jury, which is going to depict the wound. I don't think that they're going to be so shocked or horrified to see another photograph depicting the same wound with slightly different lighting conditions, which are going to assist them in looking at the redness of that wound, which is one of the bases upon which is determined whether the wound was antemortem or postmortem. Ms. Abramson says, well, if counsel is suggesting that 12 Mary, that his people are going to say 12 Mary is a more accurate description of that wound than 14 Mary, then why is 14 Mary here? He can use 12 Mary and 13 Mary and illustrate everything. I mean, the problem is the constant repetition. If 12 Mary is the one he wants, then 12 Mary is the one he should be using for number 4 and number 5 and number 6. It shows up all of these instead of using all of these photographs. That's my point. Let him pick which one illustrates whatever he is trying to prove instead of just heaping on every single, and this is every single headshot or head photo of Mrs. Menendez, whether it's particularly, even by his admission, particularly probative of what he wants to prove or not. So I think that's the issue. Whether he thinks it is most probative, although I am not sure he understands whether it's because better for the case or worse for his case that it looks dark. Mr. Khan, well, 12 Mary and 13 Mary still do not adequately depict the injury to Kitty's right eye, so you really can't see the injury to Kitty's right eye in 12 Mary, and her eyes are not even visible in 13 Mary, so you still need the photograph which is going to depict the wounds to her right eye. Now, one of the photographs that depicts the wound to her right eye is 10 Mary, so Miss Abramson says, and 14 Mary. Mr. Khan says, and then the problem, Miss Abramson says, 14 Mary does also if you wanted to use it. Mr. Khan says, no, 14 Mary does not. Miss Abramson says, sure it does. I love her. Mr. Khan says, no, 14 Mary does not depict the wound. You cannot see the wound clearly in 14 Mary because of the angle. You can't see the holes where the wounds are in the area along the top of her nose and her eyebrow in 14 Mary. You can see that in 10 Mary. The court says, well, 14 Mary is a rather, I don't know if it's the nature of the photograph, but it's a rather fuzzy view of the whole thing. Ms. Abramson says, I think he has a much clearer image off the computer at that point, Your Honor. All of his images are much clearer than what you're looking at is just a third generation. The court says, getting back to the photographs of Mrs. Menendez's face and head, are there any here that the people feel are duplicative? Or, Mr. Khan says, I think provided that, it seems to me there are 5 photographs in issue here. If we could get in 12, 10, 13, and 16, then I think 8 and 14 could be taken out. Ms. Abramson says, let me see, 16, which one is 16? The court says 16 is the torso or upper. Mr. Khan says it's the clavicle and jaw. The court says shoulder area and the jaw. Ms. Abramson says, I don't remember. Let me see what you're calling 16. I have 10, 12, 8, 14, 13. Court says 16 is the new one. Ms. Abramson says, oh, that's why I don't have it in my printout. Yeah, I need to see. Oh, 16 is the one with the mouth open that I objected to because it's particularly grotesque, and I think I showed the court that that could be cropped to remove the mouth portion. But I still think that you need let me look at what he's saying he wants. He wants 10, 12, and 13. 10 to show the eye, 12 to show the cheek, and 13 ostensibly to show the arm, hand, clavicle. Is that what is that what it's for, Mr. If you can ask counsel directly, is that what that's for? Mr. Khan says 13 shows the arm. Ms. Abramson says right and the hand and the clavicle in association. Mr. Khan says, well, it's not a very good look at the clavicle. I think that 16 shows the clavicle much better. Ms. Abramson says, well, if that's true, then 13 should be cropped to remove the rest of the photograph showing the face again and the clavicle if that's its main purpose is to show the arm. We're almost done here, guys. There's not a whole lot more to go. We got a little while, maybe like 15 pages more of this argument. So sorry, this is kind of dry and boring, but you can actually see though that the state is really trying to put some gruesome stuff in and be repetitive to, especially I think with Kitty's face and her face wounds and her head wounds, to really mm, enrage the jury, I guess, to make them feel something. It's to get them on your side with sympathy, empathy, to make them feel horrified by the crime. When in reality, it's the type of gun that they used, and they could have used pistols, handguns, and it wouldn't have been so gruesome. The wounds wouldn't have been so awful, and therefore, but the result could have still been the same. They still would have ended up dead. So we're just going off of, oh, it's such a gruesome crime because they used shotguns. Really? Shotguns were what they were able to get in an emergency because they were in fear. But anyways, Mr. Khan says, "Oh, again, I would object to any cropping because we want to present the evidence through the use of a monitor so that the jury can see them clearly." Ms. Abramson says, "You can crop it that way." The court says, "One person at a time." Mr. Khan says, "And we can't ask the jury to turn their faces away from Dr. McCarthy while he proceeds to crop the photograph for them." And what? And plus, I don't think that there's anything you can crop the photograph before he displays it and have it ready for display. And plus, I don't think that there's anything unduly grotesque about looking at a human mouth. I think that the cases that deal with gory photographs under Evidence Code Section 352 are concerned with unnecessarily showing the jury open wounds for no reason, and I can't recall a single case which says it was an error to allow the photographs because the victim's mouth was open in the photograph. Ms. Abramson says, "Well, it doesn't have to do with the fact that the mouth is open. It's the particular angle of the photograph that's particularly grotesque. And as far as cropping with the screen on, you can crop them and then load that image on your CD. And that's what you call up. Exactly. It's a permanent image. You enlarge it, you crop it, you keep it." This is 1996, guys. People didn't understand technology quite as well. Although I think that's an excuse because I'm pretty sure the prosecutor knows that you can crop an image, save it, and use that in your display instead. But whatever. I think he's just being disingenuous. So he doesn't have to go roaming through in front of the jury. He simply replaces the image with a new image which has been cropped. And I showed the court how that can be done with that particular 16 Mary previously where we did that. We cropped it. We loaded the cropped image and we printed the cropped image. The court says, "I looked at that cropped image and it doesn't really, by cropping it, it distorts the view as I look at it. You really can't get a feel for the location of that wound in relationship to the rest of the anatomy." Ms. Abramson says, "Well, you can't for 9 Mary either." The court says, "I am only talking about that one that you are discussing here. I have to look at what the number is. 8, I guess. Is that right?" Ms. Abramson says, "16 is the one you're talking about." The court says, 16. Ms. Amerson says that's the one we cropped as 16 because it was particularly grotesque and it was added after we already had 6 other images that were similar. The court says, "I'm not talking about anything else other than referring to the particular cropping. I don't see how the cropping helps and it distorts the photograph and changes its image." Ms. Amerson says, "Well, I don't understand why 16 Mary is even necessary." The court says, "We are talking about 16. I am just responding to your observation that the cropping is a good idea. In this particular photograph, it is not a good idea, would not be. As far as whether that photograph is better than another one, that's a separate issue. I am not talking about that." Okay, anyway, getting back to Mr. Khan, your view is that you can function with 10, 12, 13, and 16 and not use 8 and 14. Is that what you're saying? Mr. Khan says yes. Ms. Abramson says, "And I don't see why he needs all of those 10, 12, 13. I don't know why he needs 16 at that point because 10 shows the upper part of what's 10 shows what's on 16, and if there is any part that's missing, 13 shows it." Mr. Khan says the testimony is going to be that the wound to the jaw and the clavicle was all part of one wound in addition to the wound to the right hand. And Ms. Abramson says no one disputes that. That's what Dr. Golden said. Mr. Khan says, and if I may finish, this Mary 16 shows the relationship between the wound to the clavicle and the wound to the jaw. It shows the distance better than any other photograph. It shows the space involved. It also shows parts of that wound which you cannot see in any other photograph. For example, Mary 13 shows 2 entries in the area of the clavicle, but it doesn't show all of the other entries. There are more than just 2 entries to the clavicle. There are, Miss Abramson says 9 shows it. Mr. Khan says there are several, and I don't think that we should have to paste together photographs to show the jury. Miss Abramson says 12 shows it. Mr. Khan says that the wound to the jaw or the wound to the hand and the wound to the clavicle could all be one part of the wound. The only way we could get there is counsel's notion that we are going to paste several together. We are going to paste 9 together with 10 and 13, and maybe if they can kind of Imagine those three photographs together. They will have a pretty good, with a little imagination, they might be able to imagine what 16 depicts. Miss Abramson says, well, if they can't figure out, Mr. Khan says, I mean, why would we even ask the jury to engage in that process when 16 depicts what we're trying to depict? Miss Abramson says, if 16 depicts what you're trying to depict, you don't need 9 either. The fact is that one wound no one disagrees with. It was in Dr. Golden's testimony. It's uncontested by Dr. McCarthy. It's uncontested by Dr. Lawrence. I can aver that it's uncontested by our experts that coroner's wound number 3, which is the clavicle mandible affiliated with wound number 10, which is the right hand, is undisputed in this case, always has been, always will be. Mr. Khan says, I wish I had a list of everything that counsel does not dispute in this case because it might be very helpful to us. But until we have that list, we want to be able to depict those wounds clearly to the jury. The court says, well, even if it's not disputed, if a photograph is illustrative of the wound and illustrative of the people's theory or the defense theory, it's still admissible. It doesn't have to be in dispute. Ms. Amerson says, well, but counsel is making it seem like he needs their 3 or 4 different photographs to illustrate the same thing when it's not even a very crucial point. Mr. Khan says, I think that if anything, we could take 9 Mary out. Let's take 9 Mary out. Ms. Amerson says, well, I was suggesting that as well. Mr. Khan says, let's do that. If we take out 9 Mary, 12 Mary, and 14 Mary, then I think the other 4 photographs, 8 Mary, 10 Mary, 13, and 16 Mary. Mrs. Aberson says, we're back to 8? No, I'd rather have 8 out than 9. The court says 9 is certainly not controversial in any way. Ms. Aberson says, right, it's just, but it shows what Mr. Khan says he needs to show. Mr. Khan says, no. Ms. Aberson says, which is how many wounds are in the clavicle. The court says it shows a perspective of it, not the whole wound. Mr. Khan says, but the problem with 9 is that it's so hard to put it into perspective. The court says for somebody to look at 9, it would be difficult for the lay person to associate that with a particular portion of the anatomy. Ms. Abramson says that's why it's just extra. It should just go away. The court says unless the wound or the track of the wounds or the shape of the wounds is significant in some fashion. Ms. Aberson says, so the court says, all right. So I don't know how 9 came into it because that's not the one of the photographs that we're talking about originally. It was 10, 12, 13, 16. The people said that they could function with and delete 8 and 14. Mr. Khan says, okay. The court says, I am looking at 8 and 14 and looking at the others. I don't see anything about 10 or 12 that is unduly prejudicial, just different aspects of the head and the upper torso. The fact that her eye is open is there is nothing inflammatory about that. I disagree with that. That's just the way the body was found. But it also makes it more real to the jury when they see faces, when they see things that they can recognize. Your body, like your mind looks for patterns and recognition. That's why you see faces and patterns and like wood grains and things like that. You know, you see patterns and things because your brain wants to see that and it will make shapes even when a shape isn't there. So when you are looking at the wounds and just like a particular body part, like here's just a portion of an elbow, you're not necessarily you're kind of you can still separate it from that's a human, that's another human being. But when you see their face, that like you're there, you're in that position where you are going to feel something, especially emotional, tugging at your emotions when you start to be like, oh yeah, that's a human, I see a face, I see eyes, that used to have life, and then now it's starting to become prejudicial, if that makes sense. I hope that made sense. So the court says, I'm looking at 8 and 14 at the other, and looking at the others, I don't see anything about 10 or 12 that's unduly prejudicial, just different aspects of the hand and the upper torso. The fact that her eye is open is there's nothing inflammatory about that. That's just the way her body was found. Okay, so at this point, the people are agreeing to removing 8 and 14. What else then is in dispute as to Mrs. Menendez here that we haven't talked about? Mr. Khan says, I think that's it. Ms. Amerson says, I think those are the photographs. Court says, okay. Are we overlooking something that the court can see that I can't? Ms. Amerson asks. The court says, no, I am asking you. Ms. Amerson says, so what we have in is 10 and 12. The court says 13 and 16. Ms. Amerson says 13 and 16 of the face photographs, and the others are other parts that weren't objected to. The court says 8 and 14 have been removed. Okay, better than nothing. The court says anything else now on photographs. Ms. Abramson says no, but I am a little concerned about what Mr. Khan introduced this discussion with, which is that the court says, do you want these back? Ms. Abramson says, yes, I do, Your Honor. Okay. Ms. Abramson says that we are operating under a false premise that Mr. or Dr. McCarthy is not going to testify the same way he did before. The court says, no, I think Mr. Khan said he might. I got the impression you would add to that, to what he said. Mr. Khan says, right. Ms. Nahara says, right. The court says his testimony was not as full or complete as it would be before the jury, and I assumed that that would be the case because it was just a hearing. Ms. Nahara says, for foundation. Ms. Mr. Khan says, right. So they must have had a hearing pre-trial with Dr. McCarthy that we're not aware of, and we didn't get to read. So that must be what they're in reference to. Ms. Abramson says, and I'm relying on the representation that there have been no changes made to his diagrams since that last CD we were given, which contained those diagrams. Mr. Khan says, once again, I told counsel the numbering. There is now a number in the upper left hand corner depicting the sequence. Ms. Abramson says, meaning A1, 1A, 1B? Mr. Khan says, yes. Ms. Abramson says, I have already numbered mine. The court says, those are the exhibits that are going to go to the jury that are numbered. Ms. Abramson says, are the images on the CD numbered? Mr. Khan says, no, I don't believe so. Ms. Amerson says, and we still do, Your Honor, object to the projection of these images. I don't even know the size the monitor is. Counsel hasn't told me, but projecting them in very large images, we think, since they have hard copy photographs, and since Dr. McCarthy didn't want to leave his computer behind, and since we are not in possession or position to project images, I think it's improper to project images such as these. I don't care if he wants to project his diagrams, but to project those ugly photographs into huge images, we think interferes with the jury's ability to think because they are upsetting. I don't know if they're inflammatory, but they are shocking, and it takes a long time, a very long time, to get used to these images. The court says, well, my view is that the photograph, whether it's displayed by projection or shown in a large version, is still a photograph, and it's illustrious. The purpose is to illustrate the testimony of the witnesses, and there are, from what I have heard, from opening statements, from all these discussions, issues in great dispute and controversy, and for the purpose of illustrating the testimony of the witness, the display of them in a projection mode is appropriate. I agree with Leslie Abramson not to project them onto the big screen, although now they do everything on the big screens in trial. But back then you didn't, and they didn't even have the option. The defense is saying we don't even have the option to use a projector. But why is it fair that the state gets to? It's not right. And it shouldn't be, I think, up on the board. If they want to pass it around while the witness is testifying, and then, people can take their time and look at it or not look at it, but not displaying them up on the big screen, and it would be very distracting unless the witness has to like use a pointer and say, this is what I'm talking about in this particular picture, then you don't really need it. All right, he says, I don't see that there's anything prejudicial or inflammatory. Who's talking? I don't remember. The court. I don't think it would inflame the jury in any way, but it would assist them in evaluating this. Ms. Abramson says, I just think the oversized scale is not appropriate. The court says, I don't know what we're talking about size wise. Ms. Abramson says, I don't either, but I think it's going to be bigger than a breadbasket. Mr. Khan says, I think, as it turns out, we will be using the same monitors as we use to play at close range. Ms. Abramson says, which is huge. Court says, it's not a huge projection. Ms. Amerson says, it's not like an Elmo, thank God. We couldn't put it on an Elmo in this room. The Elmo is like what um, they display uh, like hard copy evidence things on the board. It's a projector in court, what they use. It's the technology that they use. The court says it's just a television screen, just a television screen. Ms. Nahara says it's not even a big television screen. The court says, and it's going to be used by both Lawrence and by McCarthy, or just McCarthy. Mr. Khan says, no, just McCarthy. The court says, so Lawrence is just going to use the photographs themselves? Mr. Khan says, that's correct. Ms. Abramson says, okay. The court says, all right. And any idea how long Lawrence's testimony would be? Mr. Khan says, I imagine his direct will be a couple of hours, and I am planning on using Dr. McCarthy's on Tuesday. Hopefully, we'll be finished with Dr. Lawrence on Monday, although I think Dr. McCarthy will be here on Monday as well. So, if necessary, we could get to him. The court says, all right, at this point, I am sure the defense can't really give a time estimate until you hear the testimony. Ms. Amerson says of Dr. McCarthy, well, no. Lawrence? Dr. Lawrence, yeah. Ms. Amerson says, probably I'd need to cross-examine him for, it depends. I am still not real clear on what he's going to say. Maybe 2, 3 hours of cross-examination, 2 days with Dr. McCarthy. The court says, and this will be the end of the people's presentation. Yes, says Mr. Khan. So we're very close to the end. We've got another week and it's all medical testimony, and then that should be about the end of their case in chief, not mentioning the rebuttal. They'll have rebuttal witnesses and we'll get to them, but in time after the defense goes. So Mr. Khan says, yes, it's the end of the case in chief. And then the court says, have you had a chance yet to look at exhibits and discuss things that might be in dispute? Go through your list to see if there are any exhibits that are in dispute. Ms. Abramson says, we haven't, but I am sure I can certainly delegate that to Mr. Levin to start looking since I am going to be a little busy with blood and gore for a while. The court says also still the transcript of the Oziel tape recording. Ms. Abramson says needs reconciliation. The court says, if you can narrow your disputes so that you can give it to me to review. Okay, anything else then that you want to discuss before we take our recess? Mr. Khan says, no. The court says, okay, we'll see you back on Monday at 8:30. Ms. Abramson says, thank you, Your Honor. And scene. And that is the end of week 4. We will continue next week with week 5, starting with Dr. Lawrence, who's the pathologist, who I believe is going to be on the stand for about 2 days. And then Dr. McCarthy is going to finish out the week. So it's going to be a lot of medical testimony that is, to me, medical testimony can be quite dry, boring, hard to read, hard to get through, but we'll get through it, and I'll try to make it as interesting as possible. Although I don't know, we'll see how that goes. Also, he was talking about the Oziel tape. I'm gonna see if I can find the Oziel tape. I don't want to just play it again from court from trial 1. If there's a Oziel tape that is used in trial 2, if it's the same tape, I have no idea. I'm gonna do some research on that and see if we have an Oziel tape that we can listen to, at least the audio of it from trial 2. So I'll look for that and see if I can find that as well. So that's where I'm going to leave you for this week. And next week, we will start with week 5 of the 1996 trial testimony of California versus Erik and Lyle Menendez. Please don't forget to hit the subscribe button, hit that like button, and I will talk to you guys later. Bye. Take care.